Hey everybody, it's Christopher Small with CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I wanted to talk to you about a little rule I call no will does not equal no rules. If you have questions about this or anything else, by the way, as we go through this, you can set up a time to talk with me over the phone or in person for free by going to estatemeeting.com. That's estatemeeting.com. All right. Today's video comes as it usually does from a conversation that I had with a potential client this morning. This potential client had a grandfather who had passed away, and this gentleman died without a will, and there are several children and grandchildren and all sorts of people in place, and she was coming to talk to me because some of the children had their own ideas about the way that all of the money was going to be distributed. And I made it a point, and I wanted to make it a point here on this video to let you know that whether there's a will or not, there is a specific way that one's property is distributed when they die. You do not have any leeway over the way that property is distributed. What I mean is this. Let's say, for example, there are 3 kids and $90,000, and someone dies with no will and no spouse. Okay? Under that scenario, in most cases, the $90,000 would be split equally amongst the 3 kids. Now, if kid number 2 has declared bankruptcy, for example, and does not want that money to hit their account because they do not want it to go straight to the bankruptcy creditor, they cannot say, hey, let's, instead of giving me the money outright, let's move that money over here to my friend Susie, who will then hold it for me, right? Until it's good to go. You cannot do that. That money has to be distributed out to that person, and it will just go where it's going to go. Okay. The solution in that case, if you are the person that's passing away, and you know that the person you're giving money to has bankruptcy, is to put it into a trust, and then it can be used in several different ways. But if you don't do that, if you fail to take those steps, then the money will just go to that person. An important scenario, one that is realistic and one that I was talking about today, was if you have someone that is disabled, okay, that they are receiving some sort of benefits, need-based benefits, okay? Let's say they have a physical limitation, a mental limitation, some sort of disability that for which they get some sort of benefit. If you don't have a will and you give the money outright to that person, there is a significant chance that those assets will count against that person when it comes to determining whether or not they're eligible for those benefits. Okay, that's a big problem. That was something that we talked about today. It's something that happens and can arise frequently. There are some ways around it, but it's so much easier if you create a special needs trust before that problem arises. All right. So to recap real quick, no will does not mean no rules. Even having a will does not mean no rules. You are going to have to follow the state rules of asset allocation if you do not have a will, and you can't negotiate around that. You can't all really agree around that. It is what it is. The assets go where they're going to go, and whatever happens with them kind of happens with them. All right, that is it for today. Hopefully you enjoyed this video. If you did, hit the like button. If you know someone that needs to hear this, please share it with them. If you have a question or comment, please leave it. Once again, I am Christopher Small. I'm the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. If this video or any others have sparked your need for help, you can go to estatemeeting.com, set up a time to talk with me over the phone or in person for free, estatemeeting.com. All right, that's it for today. Thank you so much for your time, and I will talk to you again soon.